Ladies and gentlemen and ladies, got a little bit of Maxwell and his pretty wings. Got some hot sauce and some chili sauce going with them pretty wings of Maxwell. And ladies and gentlemen, we're going to read something to y'all because let me tell you what I'm doing here. I decided I've been working on some legal documents and I'm getting ready to put together a lawsuit. Which is why you guys, like I said, I'm working with a particular young lady on her paperwork, and she is the only one who I'm helping at this time. Nobody else, so don't ask me. Not helping you, not doing it. Told you I'm going to focus on her and the defrauded homeowners of America. By the way, we're still waiting for the judge to respond on the defrauded homeowners of America. I will update those of you very soon in an email as to the other things we're getting ready to do. I have to be very careful because you have to understand some of the people who are part of the defrauded homeowners of America, at least one or two of them are not who they're supposed to be. They're looking to get strategy. And I have to be very careful of revealing all of the strategy to you in such a fashion or format. Okay, sorry, it's just the way the system is. So you guys just have to understand it. Now, we're going to read something to y'all because we need y'all to hear this. So we're going to turn down Maxwell and we're going to let it talk to y'all.
Such legislative or administrative jurisdiction, it is well settled, cannot be conferred on this court either directly or by appeal. The latest and fullest authority upon this point is to be found in the opinion of Mr. Justice Day, speaking for the court in Muskrat v. United States 219 U.S. 346. The principle there recognized and enforced on reason and authority is that the jurisdiction of this court and of the inferior courts of the United States ordained and established by Congress under and by virtue of the third article of the Constitution is limited to cases and controversies in such form that the judicial power is capable of acting on them, and does not extend to an issue of constitutional law framed by Congress for the purpose of invoking the advice of this court without real parties or a real case, or to administrative or legislative issues or controversies. Hayburn's case, 2 Doll, 410.
Now, I want you guys to understand something. The first thing, the constitutional courts cannot operate. They don't have the authority or power to operate without real parties being involved. I want you all to pay attention to something. I'm going to tell you this because I don't lie to you when I'm doing these videos. It would make no sense for me to lie to you. I don't know what date this case was had, but I promise you it's before 1933. How do I know it's before 1933? Because they talk about the principle recognized and enforced was the reason that they had no authority to act outside their jurisdiction. That the courts could only act judicially. They could not act administratively. Okay? So without real parties or to administrative or legislative issues or controversies, they could not act administratively. Why? They didn't have the authority. They can only handle administrative questions. So hold on. As far as whether or not such and such had the right to do this and such had the right to do that. So what we're going to do is we're going to, not right, but left. Let's go up here and look at the date of this case because I don't know the date. But like I told you, before 1933. How did I know it's before 1933? Because that's when they changed it to an administrative system. So that's how I know what the decision was. That's how I know what they were doing. Now, what did I do? Well, I took a case. What case did you take, sir? I took this case right here, Keller versus PE. This is the actual statute where I could find it. What I want to do, what do you want to do? I want to do this one right here, okay? So we're going to copy that. We're going to come here, and then we're going to go here, and we're going to paste, and we're going to enter, and we're going to see if we can pull up this case. Okay, I would love to pull up this case, but I don't want to pull it up like this. See how they mention the case in other cases? But I want to pull up to see if it's been found. Page 1 of 72. This makes it difficult because what is the ruling in the case of Thompson versus? Let's go here. Because it's asking, it actually lets me know there's an actual case. See, sometimes when you go to sites that list cases like this, right here, sometimes all those cases are not legitimate. because the system puts those cases out there. This is Yahoo Answers. Okay, I don't want Yahoo Answers because Yahoo Answers is who wants to rely on Yahoo? Yahoo! Okay, so let's just look for the case itself. Yeah, let's go here. I don't really want to get rid of that because there's a search there that I've been doing. So I'm more interested in my search. Y'all just don't mind, do y'all? Okay, it's actually telling me that I can download the full PDF, y'all. So the case, and look, Supreme Court. So, but this ain't what I'm looking for. Oh, look at this. They actually have the case here on screen. Oh, because it's one of them cases. It's one of them cases that was had so long ago that long ago don't even know what long ago was. See, I'm saying Act of Assembly approved March 1st, 1903. Interesting, ain't it? And it wants me to subscribe. Oh, certainly. I'll subscribe. Why would I subscribe to this junk? So, now, oh, please. Script dip. I don't want to be a part of Script. Somebody gave me their access to Script, gave me their information, but ladies and gentlemen, I don't care for Script dib. I could care less for Script. Okay? This is that, yeah, that's that Yahoo Answers. I want the actual case. I don't need you guys to find it for me. Why don't you need us to find it? You can't find it yourself. Actually, it's not that important. I'm looking for a particular set of words. Okay? See, I don't want those because that's where it takes all of these cases and puts it in one place, like Freedom School and all that. I don't want that. I want the actual case. So this one says Supreme Court, Virginia. Okay, but see, it puts this case and mix it in. So let's see if we can find it, y'all. And I can do the text search. Uh-oh, it's gonna do a PDF. Okay, well, I'll take a PDF. I didn't say document. I said general. Join the general. General. Okay, now we have that. Now let's do the text search. T-E-X-T. Ladies and gentlemen, because we know that Congress did what it did, because we know that they didn't have the right to do what they did, we're going to have to see what we can do about going in court. As a matter of fact, I was playing something back, and I'm going to play it back for you guys so that y'all can see. But what I want is the actual case. This seems like it might be it, but is another one of them PDF. So let's see if we can pull up the other PDF and see if it's in that PDF. Y'all wanna take a look? I want to take a look. We're going to let this read in a minute. This is the same information that you guys already know. I'm waiting for it to pull up because it hasn't pulled up yet. So let's let this read for a second so you guys can see what I'm doing.
These hundreds of statutes delegate to the President extraordinary powers, ordinarily exercised by the Congress, which affect the lives of American citizens in a host of all-encompassing matters. This vast range of powers, taken together, confer enough authority to rule the country without reference to normal constitutional processes. Under the powers delegated by these statutes, the President seizes property, organize and control the means of production, seize commodities, assign military forces abroad, institute martial law, seize and control all transportation and communication, regulate the operation of private enterprise, restrict travel, and, in a plethora of particular ways, control the lives of all American citizens.
Agenda 21, enacted during the reign of Bill Clinton. That's exactly what it does.
The one initial exception to the foregoing framework for national emergencies concerned the Trading with the Enemy Act. As first adopted in 1976, the National Emergencies Act excluded from its purview Section 5(b) of the Trading with the Enemy Act. As noted above, that is the provision.
Ladies and gentlemen, not Section A, Section 5B was excluded. Now, does that mean Section 5A is not included? Section 5A was not part of the National Emergency Act. So yes, it's still in effect. In full effect. But with regards to the national emergency, it's Section 5B. That's the focus.
Of law under which President Roosevelt issued his declaration of national emergency with respect to the banking crisis. But with the advent of the Cold War, that section had also been used by the executive branch as the legal basis.
Ladies and gentlemen, I want you to understand, this is not from no sovereign site or anything like this. This is the actual wording of Congress. This is them actually talking about this. This is not me making this up. So that's why I'm having it read, because I need y'all to focus on this.
For imposing economic sanctions. As a consequence, the State Department asked that Section 5B, the March 9, 1933 Act, otherwise known as the Emergency Economic Bank
added that part.
Relief Act, a national declaration of bankruptcy, be excluded from the National Emergencies Act until other legislation providing a basis for the continuation of economic sanctions against those countries could be enacted. There has been no further legislation provided by Congress.
This part.
In fact, the United States Congress has not revisited this matter since the enactment of the National Emergencies Act of 1976. I do hereby present this my appeal on this day to be construed contextually, and to have the determination made as to whether or not one has the right to do an adverse possession on a property for which they have had possession of for greater than 30 years, even if there is a claim that all properties in the United States are owned by the United States Senate Document Number 43, 73rd Congress, First Session. I have the right to property under the Right to Property Clause. I also have constitutional rights that are still in effect, as I challenge the constitutionality of the March 9, 1933 Act, otherwise known as the Emergency Economic Banking Relief Act, as is my right. I also challenged the statute that allows the judges of the courts of the great state of Washington to operate in an administrative capacity, camouflaging and or disguising themselves to be the judicial branch of government by carrying a name similar to that of the judicial branch. This is a blight on public perception. It blocks access to the court and to justice, and is a violation of the Separation of Powers Clause, since the courts have been delegated by the Constitution to be only of the judicial branch of government. And even if that were not the case, the issue still remains, is I have a right to be before he constitutional venue known as the judicial branch of government, and I need this court to state with specificity where that court may be had, its address, its telephone number, and the rules and procedures for that venue, and not the administrative judicial courts which are under the administrative branch of government, which practice commercial business, continuously stripping them of any claim to sovereignty.
That's called the Clearfield Doctrine. As long as they practice commercial business, then they have no jurisdiction. What I put in the document that I did, and there was a place where it said he as opposed to thee, I have to go back and change. But the Clearfield Doctrine basically says as long as they practice commercial business, they have no authority to operate as the judicial branch. Ladies and gentlemen, what I am suggesting, pay attention, because this is the reason why I'm doing this video, is because of what I'm about to state now. By bringing up the statement that the courts practice, pay attention to the words, commercial business, they surrender any claim to sovereignty. Commercial business, comma, abandon sovereignty, question mark. Ladies and gentlemen, what I'm doing right now is I'm just pulling up some of the cases, but you want to pull up, no, I want the, oh God. Enters into commercial business, abandons sovereignty. I'm doing that because enters into commercial business, okay? And you can find it at this guy's site, but what we're looking for, because that's the phrase we're looking for. A tenant entered into commercial lease. We don't care about commercial lease. We said commercial business. So I'm going to have to put that in quotation. But here's another one. Of society and must and of sovereignty. Okay? So it's called the Clearfield Doctrine. Anytime the United States or any government, doesn't matter. This is international law, people. This is not United States law. So you don't have to rely on United States Constitution, but this is United States law that anytime the government enters or engages in commercial business, it abandons its sovereignty and is to be treated as any ordinary corporation. Got to talk to them. They coming to replace my automobile glass tomorrow morning. And so I'm going to let them replace my automobile glass. TikTok, I don't think it's going to let us get to that site. Let's do this. It's giving us a PDF option. No, I don't want the PDF option because that's not even giving me, yeah, that's not what I'm looking for. Not what I'm looking for, Chief. That's not the one I'm looking for, Chief. So pretty wings are. Maxwell. All right. Interesting. That's not even the phrase I'm looking for. I'm looking for where it abandons its sovereignty. So I'm glad that I did stop when I did, because we'll just stop. Okay. Pretty wings, chicken wings, barbecue wings. Look at that. It doesn't want to have abandoned sovereignty. It's supposed to be abandoned its sovereignty and it's to be treated as any other. Don't know why I did this. I should not even be looking up this because I done showed it to y'all time and time again. But you guys know how I be. Okay? Y'all know how I be. If I say something, I got to prove something. Okay, hold on. Okay, I put enters. So let's do engages in commercial business. No. No, I can do it in Google. Well, let's do it in Google, y'all. Copy. Uh-oh, it didn't do it. No, I didn't want that. Go back. It's supposed to be copy. Then I'm supposed to do, we'll do Google. I don't want no Google, Facebook. I just want Google. So give me my search engine. Okay. Well, their search engine, because it ain't mine. I don't use it no more. Okay. This is whenever the United States or government enters into commercial business, it abandons its sovereignty. See, abandons its sovereignty, capacity, and is to be treated like any other corporation. What does this mean? Ladies and gentlemen, this means that they willfully give up and waive any right not to be sued. The moment they enter into commercial business, they elect to be sued. Okay? So this is for you to know. Now you can find this. This is the Earthlink site. Hey, is this my Diamonds and Pearls by Mr. Prince? Ladies and gentlemen, Prince is in the background and he's singing Diamonds and Pearly Earlies. Okay, so what I'm suggesting is some of you legally wise people, I've been running into this lately, not pulling up sites, but I have been pulling up the copies that they have. So watch this. Hear me say, let's do, I just want the phrase right there. Well, look at that. It says none. Okay. I'll just do capacity. Okay. See, this is one of those sites. They quote corpus juris secundum, but it's not corpus juris secundum we want to rely on. It's the actual law. So I do know that one of the laws is the Summer case. or Sumerlot case. This one is one of the cases where the actual phrase is there, but I thought this one was going to give it to me and this one was going to give it to me, but you see they didn't give it to me. So basically your claim is that they see when the United States enters into commercial business, you can get it from United States Playing Cards Company. By the way, do you understand that this is a corporation of the United States? Because no one is allowed to use the word United States in their title. Or District of Columbia. Okay, but pay attention. United States Playing Card Company was done before they came up with that District of Columbia code. Look how old this case is, 1824 and 1916. Look at that. Look how go way back. But as long as you all understand that this is the way it is, all you have to do is claim that they were engaging in commercial business. They have no sovereignty. I found in Virginia, do you know that there's a case law that says that the courts, you cannot call a judge to testify? What you mean I can't call a judge? You can't call a judge to testify. See, look, ladies and gentlemen, I thought this was a 1903 case. So, United States Playing Card Company, trust me when I say to you, it is against the law to use the United States or District of Columbia in your title without asking for permission. I know that because I showed you guys the DC code that speaks to that. D to the I to the A to the N, O to the N to the D to the girls of love. Diamonds and Pearls. I believe, was this Prince in the Revolution? I believe this was Prince in the Revolution. Yeah, this is Diamonds and Pearls. Well, anyway, Diamonds and Pearls, y'all. Hold on. Let's do that right there. No, we don't want that capacity. We want this capacity. This one right here. Okay. Notice what it says. Florida Department of Business Regulations versus United States Department of Interior. That's that case that deals with this. It says determine whether or not the government is entitled to sovereignty. The threshold question is whether the suit is won against the United States as a sovereign. Exactly. Thank you. And what did they determine? Let's find out what they determined. When the United States enters into commercial business, it abandons its sovereign capacity and is to be treated like any other corporation. And here is your case. Okay, that's only one case. Here is two cases. Okay, there's two cases, and there's your third case, y'all. Okay, suits against the club is not a suit against the United States in its sovereign capacity. Therefore, we retain jurisdiction over this action against the club. Okay? So, there you go. You have proof that if you sue, you don't sue the United States in its sovereign capacity, you sue them as a corporation. And you keep going until they let you in the door, people. They want to deny you a right. They want to say you must have a driver's license, you must have an ID that they produce through one of their corporations. Then sue, people. I'm not asking you to have some civil disobedience. Please, I'm not asking for that. I'm asking you to stand up and say, I have this right. Leave me alone. If you don't leave me alone, then I will use your administrative courts to bring attention to this matter so that they will hopefully get you to leave me alone. Because I never meant to cause you any pain. All right, ladies and gentlemen, so my hope is that some of you will understand what I just talked about in this video, about how you have the right. You have this right, okay? The Bicycle Club. Pay attention, ladies and gentlemen. These are both United States companies, okay? The club and the card company are both United States companies. That's what the Supreme Court just said. You didn't see it? I know. I wouldn't have saw it if I wouldn't have paid attention. It says suits against the club is not a suit against the United States in its sovereign capacity. These two companies are United States companies, people. Are you catching me? And even if it was a state against the United States in its sovereign capacity, remember, once they engage in, pay attention, Once they engage in commercial business, they willfully abandon the right not to be sued. That's what this means. That means that they waive their right to sue. That means you can sue them. I know you don't understand, but it's okay. This is for the people who understand law. By the way, ladies and gentlemen, go. Okay, let's do this. JUDICIARYACTSEPT 24 17 89. Oh, I said this is, yeah, 1789. I was right. This is 89. 89. Come on now, 89. Judiciary Act 1789, September 24th. Now I want the text. The reason why I want the text, because I want to show you guys something. I was having a conversation with somebody earlier today, and it realized in that conversation that they didn't understand this. So what I want to do is I want to show this to you. Okay, this is the Judiciary Act. This is the act that established the judicial courts of the United States, not administrative. This is the act that says, well, let's do it. Let's show you. Okay, hold on so you guys understand. There was no difference between civil and criminal. They were both held in the same court. There were no separation. See? Cognizable of all crimes and offenses that shall be cognizable under the authority of the United States committed within their respective districts and upon the high seas, where no other punishment than whipping, not exceeding 30 stripes. Give them 30 lashes. 29 plus 1. That's why they only gave 29, because if they went over that, they'd violate the law and be in trouble. And a fine not exceeding $100 and a term of imprisonment not exceeding 6 months. Pay attention, term of imprisonment and a fine and corporal punishment, people. Civil, criminal, same law. You can go ahead and read it and it'll tell you. But what I'm trying to do is let you know I've already read this. So I already know that initially there was no separation. Only in administrative courts is there separation. Prior to the advent of the so-called 18th Amendment, 18th title of the U.S. Code, the criminal statute, do you have this so-called junk about civil and criminal being different? Now, what I want to do is tell you about the Attorney General. Uh-oh. I don't think it wants me to do Attorney General. I know Attorney General is in here. I know Attorney General is in here. Hold on, let me do General. Yeah, Attorney General. I know Attorney General is in here. Ladies and gentlemen, go ahead and read this about Attorney General. Now, you see, Attorney General only shows up once. Understand, the Attorney General was never supposed to represent the people of the United States. The Attorney General represented the President. He is the President's attorney. Okay? And he's the President's attorney, whether it be in its military capacity, i.e. Attorney General, or the President himself as an officer of the corporation. He is not the attorney for the people. That's why they cannot hear personal complaints. They cannot represent you on a personal level because there's no law permitting them to do that. Oh, by the way, and upon all arrest in criminal cases. Okay, they were the same, people. Just so that you know. And in the execution of his office, that in all courts of the United States, the parties may plead and manage their own cases personally or by the assistance of such counsel or attorney at law as by rules of said court respectively shall be permitted to manage and conduct causes therein, and there shall be appointed in each district to meet persons learned in the law to act as attorney for the United States in such districts, who shall be sworn affirmed. Ladies and gentlemen, they were to represent the president, not the people. Okay, it was always that way. And you notice they took this phrase, United States, without the all caps. They took that phrase because that's what it was supposed to be recognized at. They already had districts. Pay attention, because it says in such districts. This was 1789. Okay, so this is to let you know a lot of the stuff that people were saying, they didn't have the history. But the Attorney General, when you see his appointment was through this act right here. He didn't exist prior to this. But the president needed an attorney, so they gave him one. Okay? But again, if you ever have an issue about whether or not you get to represent yourself, the parties may plead and manage their own causes personally or by the assistance of counsel or attorney at law. That's where they're getting the phrases from, people. So you have the right to counsel. You don't have the right to an attorney. That is a lie. An attorney is an officer of the court, whereas the assistance of counsel does not need to be an officer of the court. He is not an officer of the court. Okay? The people who are legally wise will need to go over this and understand exactly what it's talking about. Okay? This is the same act, I think it's section number 23, that talks about no writ may be dismissed. Yeah, it speaks about writ of error, but that's not what I'm talking about. Let's see. AFFIDAVIT. No, let's do shall be dismissed. Uh-oh, it won't let me. Let's see. Affidavit, writ, reasonable person. So let's do reasonable. Okay, hold on. Let me do it this way. Let me turn off my that's y'all know my girl, right? That's Leela James. Reasonable man or woman. Understand. Stop listening. It is in the act because I've actually read it in the act. Oh, you got caught in the act. Exactly. And so it says that every affidavit shall be as any reasonable man or woman shall understand it, and that no writ or affidavit or motion or anything shall be dismissed due to want in form. So let's see if we can put up want in form. Also, 1 second, y'all. WANT. Uh-oh. Nope, not what I'm looking for, Chief. Not going to be able to find it. Oh, there it is, 32. I said 23. I don't know why I didn't pull up what I was looking for, because I know it's going to say shall be as any reasonable man or woman would understand. So, ladies and gentlemen, I got to find my mouse because it's blending in. Section 32, this is your section. Okay? It says, and be it further enacted that no summons, writ, declaration, return, process, judgment, or other proceeding in civil causes in any of the courts of the United States, all cases were civil then, as is now, shall be abated, arrested, quashed, or reversed for any defect or want of format, because you didn't fill out one of their forms, you didn't follow their format, but the said courts respectively shall proceed and give judgment according as it is right of the cause, and the matter of law shall appear to them without regarding imperfection, defects, or want of form in such writ declaration or other pleadings, return process, judgment, or other courses of proceedings whatsoever, except those only in cases of demur, that's where the term comes from, which the party demurring shall specially sit down and express together with his demur as the cause thereof, and the said courts respectively shall and may, by virtue of this act, from time to time amend all or every such imperfections, defects, or want of form other than those only which the party demurring shall express as aforesaid, and may at any time permit either of the parties to amend any defect, that's why the court asks you to amend your junk, in the process or pleading upon such condition as the said court respectively shall in their discretion and by their rules prescribe. Okay, this is where you get that quote from, that they cannot dismiss. So that's why when I write a motion, I don't use their forms, and I let them know I don't have to use your form. The court cannot dismiss it because you don't use their form. They like to demand that you use their form, but you don't have to. Oh, by the way, just looking a little bit ahead, now you guys can see that they had the death penalty back then. Okay? They sat down and thought of all of this, ladies and gentlemen, and you got to understand, this was the first judicial act. Okay? This is the act that allowed the courts to be. This is Article 3 of the Constitution. I know, people didn't know. Well, I'm letting you know. This is your judicial branch. An act to establish the judicial courts of the United States. Okay? That's why their courts, and see, pay attention, courts of the United States. All of the courts named today are United States courts. Give me 1 second. I want to check one more thing. Okay, ladies and gentlemen, I can't prove or say for certainty that this is going to give me what I'm looking for, but it's going to give me similar to what I'm looking for because it's Wikipedia. And so the people who are writing the article on exactly what I was talking about. But you see, this says Circuit Court of Appeals Act. Okay, it's letting you know about the different names of the court and all of that. Courts. See, they're saying that they also had appellate jurisdiction over the United States District Court. They talked about the Circuit Courts, United States Ninth Circuit Court of Appeals, not those circuit courts. These were different circuit courts by a different name. Okay, so, but what I was looking for in particular was when they changed the name from the United States, Court of the United States to the United States blah, blah, blah court. Oh, the reason why that's flipping, because I got my so-called voice recognition on. And so that's why it's jumping without me telling it to jump. So let's see if I can get some control. Let's go back up. Okay. Midnight Judges Act. Judges of the D.C. Circuit. Circuit Court judges appointed. It wasn't this act. Circuit Court judges of California. Nobody cares about California. Do y'all care about California? Exactly. I don't care about California. Okay. United States Circuit Court for the District of Columbia. You see, there was an act of Congress that went ahead and changed it from the United States, and I wish I could find it, but I don't know the name of the act that actually said in the act that it was changing the name from this to that. I do believe that it is the writ of error, the act that got rid of the writ of error. Okay, so it got rid of the writ of error. I showed it to you guys in a video not so long ago where they claimed they abolished the writ of error and that the appeal process serves the same process as the writ of error. That's because it all went administrative. So we have my song with Ray Charles, and this is a song for you, but it ain't gonna be a song for y'all today. What I'm gonna do is let you all get back to your day. As I said, my issue right now is we bring up the issue that the courts are operating. Pay attention. They are operating as commercial business engaging entities, which means that they are not sovereign and that we want to be before the sovereign branch of government. And we have that right. That in order for us to be before a different branch of government, we have to be licensed or we have to consent. Okay, federal district courts are grouped into circuits. The circuit courts convened separately in each district and were designated by the name of the district. For example, U.S. Circuit Court for the District of Massachusetts. Again, before U.S. wasn't in front, it was at the end. So it was the Circuit Court for the District of Massachusetts for the United States of America. Okay? So United States came last. There was an act that changed that. But nonetheless, let me let you all get back to your day. I do hope that the information, especially regarding the court and the capacity that the court sits in and your right to challenge the court's jurisdiction and you're challenging the court's jurisdiction, proved to be helpful. Remember, there are several questions. And if I had the time, ladies and gentlemen, I would play the audio of the questions that I'm asking. You know what? Let's do that. Let's give you guys the audio. 1 second. You ready? I hope so.
1. This is a matter that deals specifically with adverse possession and the right to adverse possession. 2. The question has not been entertained as to whether or not the prerequisites for adverse possession have been met, and the right to file for adverse possession is a cognizable claim supported by operation of statute and common law. 3. We placed in the record proof that adverse possession is cognizable within the great state of Washington, which makes it cognizable by this court. I subject matter jurisdiction. 4. The great state of Washington says the following, RCW 7.28.070. Adverse possession under claim and color of title payment of taxes. Every person in actual, open, and notorious possession of lands or tenements under claim and color of title, made in good faith, and who shall for 7 successive years continue in possession, and shall also during said time pay all taxes legally assessed on such lands or tenements, shall be held and adjudged to be the legal owner of said lands or tenements, to the extent and according to the purport of his or her paper title. All persons holding under such possession, by purchase, devise or descent, before said 7 years shall have expired, and who shall continue such possession and continue to pay the taxes as aforesaid, so as to complete the possession and payment of taxes for the term aforesaid, shall be entitled to the benefit of this section. 1893 C11.3, http://leg.wa.gov/coderevisor/document/session law/1893 C11.pdf. Site equals 1893% 20C% 2011% 20% C2% A7% 203. RRS 788. 5. You see, in the great state of Washington it is a cognizable statement of claim of adverse possession when a person files such a claim with the court and meets the prerequisites. 6. Who can claim property based on adverse possession in Washington? https://www.nalo.com/legal-in-encyclopedia/who-can-claim-property-based-possession-washington.html. The law says I can because I have been in possession of my property for a greater portion of 30 years continuous, open, and notorious, with an enclosure, improvements, taxes, colorable title, and the fact that Fannie Mae, a government-sponsored organization, shows that the property was fully satisfied in 2011. 7. Adverse possession in Washington is controlled by state statute, and also by the courts. Importantly, the burden of proof to establish a claim of adverse possession is on the trespasser. The legal holder of title has the presumption of ownership until the adverse possessor can meet that burden. 8. So I do hereby attach my receipt for the overpayment of taxes to rebut any information by any of the parties saying that they have paid the taxes on this property. 9. The state of Washington recognizes my claim and the court must recognize my right to a claim of adverse possession, and I must hereby object to anyone claiming that I have failed to state a claim cognizable by the court, and objected any evidence placed on the record by the opposing party who has no standing in this matter, as the person is not entitled to the property under the fundamental principles of adverse possession. 10. This is not a matter of foreclosure, that is a different proceeding. The opposing party, if they want to bring forth a claim, they will have to show proof. 11. The trustee did not have leave of the court but chose to act on his own discretion. They made an executive decision which was a violation of my constitutional rights, and renders any standing they might have in these proceedings void as a result of breach of contract, breach of trust, failure of duty of care, and once again I object. 12. The Superior Court on its own motion made a determination that a legal entity could not be sued and/or receive service of process. Despite the fact that the original complaint listed more than 35 instances where not only legal entities were sued but where service of process has been completed on legal entities, rebutting the court's original unsubstantiated presumptions. 2 questions now presented before this and to this honorable court. 13. Initially, the court judicial officer, knowing all of the facts of this matter, issued a default against the defendants. Initially, the court recognized the right to bring suit against legal entities. When the request was made for a judgment respecting the default that has already been issued by the court judicial officer and not the clerk of the court contradicted itself on the public record. 14. I informed the court that the United States government, as a result of the current national emergency, own all of the property, all of the homes of all of the people in the United States. Senate Report 93-549, Emergency Powers Statutes, provisions of federal law now in effect delegating to the executive extraordinary authority in time of national emergency. Report of the Special Committee on the Termination of the National Emergency, https://archive.org/details/senate-report-93-549. A number of conclusions can be drawn from the Special Committee's study and analysis of emergency powers laws now in effect. Congress has, in most important respects, except for the final action of floor debate and the formal passage of bills, permitted the executive branch to draft and in large measure to make the laws. This has occurred despite the constitutional responsibility conferred on Congress by Article I, Section 8 of the Constitution, which states that it is Congress that makes all laws. 15. I told the court that I was challenging its jurisdiction because its current laws are based in whole or part on the March 9, 1933 Act of Congress, and that because that act was deemed by Congress to be unconstitutional, all of the subsequent regulations and acts created as a result thereby are void of force. 16. That the Superior Court must recognize the common law right to adverse possession, and that any decision...
Ladies and gentlemen, the reason why I'm stopping it there, I almost actually stopped the video. The reason why I'm stopping it there because I wanted to explain most of the reading that was read just prior to this was basically quotes from other courts and from the actual statute and from Congress. So I'm actually using their words, and this is an appeal regarding an adverse possession, which the court failed to hear. What happens is they don't want you doing adverse possession on your own property, even though you have every right to do so. And we put in there every right to do so, but what the court said in this first case is that the person did not have the right to do an adverse possession claim against a non-physical person. So that's why the argument was that the court said that you couldn't bring a claim against an entity, where the United States brings claims against entities all the time. What I mean by entities, money, properties, just by using the address in the caption, and not an actual physical person. Okay, so let it continue. Wrong button, sorry.
Made by the Superior Court must be in accordance with the law that was acknowledged prior to the enactment of the March 9, 1933 Act, and the court ignored this jurisdictional challenge. 17. So the question is, if the judicial officer takes an oath to uphold the Constitution of the State of Washington, an oath to the Constitution of the United States of America, and he violates either of those constitutions, and or is aware of a violation of the rights of those secured by the constitutions, is this not the epitome of judicial misconduct, harmful error, that the judicial officer has engaged in conduct prejudicial to the effective and expeditious administration of the business of the courts, or has become, by reason of a mental or physical disability, unable to discharge all the duties of the judicial office? 18. Because the Act of March 9, 1933 is the act by which this court and the Superior Court has acted, this court must rule that the Superior Court acted without jurisdiction, since, as is noted throughout these proceedings, the United States Congress did not have the authority to enact the Act of March 9, 1933, an act which gave legislative powers to the executive branch, an act prohibited by Article 1, Section 8 and the First Amendment of the United States of America Constitution. 19. The declared national emergency of March 9, 1933 is still ongoing. Congress has repeatedly stated that we're still in a national emergency, in particular the one announced by the March 9, 1933 enactment. 20. Congress has made it clear that the current banking emergency created a banking holiday, and that the property in question is a government obligations, and note that I properly tendered payment to the United States Department of the Treasury. 21 United States Department of the Treasury is the Department.
Hold on. Ladies and gentlemen, in all cases, you must tender a payment. If you have a mortgage and they're claiming that your mortgage is due, you must tender a payment. You must tender a payment. Tender a payment is absolutely necessary. Remember, they're claiming there is a debt. Under the 14th Amendment, section number 4, you cannot challenge any claim of debt in the United States. It is considered something that you cannot get around, except for insurrection and rebellion claims. So tender a payment. Remember, there is no money, so tender a payment. That's what the money order issue was all about. That's why it was working, because the law just requires that you tender a payment. All you got to do is show proof that you have tendered payment. That's all you have to do. Money orders, promissory notes, they all work. Why? Because there is no money. That's why you pay them payable to the United States Department of the United States Treasury, the United States Treasury, or the United States of America. Why? Because they're all obligations of the United States. Now, again, what you're hearing is you must ask cognizable questions. So the reason why I'm doing this is because I want people to hear the way the questions are being formed. Now, this section right here is not the question. This section is right here letting them know what the rights are and what the understanding of the law is. And that if you're going to tender a payment, you must tender this government obligation for redemption as required by statute. So it puts the statute there. Then it's going to talk about adverse possession. Then it's going to get into further questions. And this is an appeal. This is not me asking the court a question. This is an appeal, so there's more than 2 questions. But if you're going to do the federal question thing, if you're going to do the questioning of the court, and you're going to do that separately to where you don't have to pay any fees, then you're going to stick to the 2 questions you heard about in the other 2 videos. So I'm going to continue.
Of the federal government that is responsible for redeeming government obligations, see Section 411 of Title 12. 22 Adverse possession prerequisites have been met. The record in this matter clearly documents this as a fact. I invoked equity when I entered into the court and presented my complaint in equity, and the lower court failed to give me affirmative equitable relief. 23 I hereby demand equitable relief, and that this court acknowledge the error in the Superior Court's decision to dismiss my complaint, ignoring all of the evidence placed into the record. 24 Second question, if adverse possession is a right of possession acknowledged by state statute and common law, did I not have equal right to access the provision of law under the Equal Protection of Law Clause? 25 Question number 3, if jurisdiction may be challenged at any time, why is it that the court ignored my challenge to jurisdiction, and failed to prove all of the jurisdictional facts on the record prior to rendering any decision? 26 Once challenged, jurisdiction cannot be assumed, it must be proved to exist. Stuck v. Medico 1 Examiners 94 CA 2D 751. 211 P2D 289. There is no discretion to ignore that lack of jurisdiction. Joyce v. the United States, 474 F2D 215. Where jurisdiction is contested, the burden of establishing it rests upon the plaintiff. Luce v. American Energy Savers, Inc., 168 I11.3D 558, 522 N.E.2D 841, 1988. The burden of proving jurisdiction rests upon the party asserting it. Bindell v. City of Harvey, 212 I11.3D 1042, 571 N.E.2D 1017, 1st DIST 1991. Court must prove on the record all jurisdiction facts related to the jurisdiction asserted. Lantana v. Hopper 102 F2D 188, Chicago v. New York 37 F.Sup. 150. When acting to enforce a statute and its subsequent amendments to the present date, the judge of the municipal court is acting as an administrative officer and not in a judicial capacity. Courts administrating or enforcing statutes do not act judicially, but merely ministerially. As an extension as an agent for the involved agency but only in a ministerial and not a discretionary capacity. Thompson v. Smith, 154 SE 579, 583, Keller v. PE, 261 The United States 428, FRC v. GE, 281, the United States 464.
Ladies and gentlemen, that's what I was doing. I was actually pulling up some of the cases, not the California case or anything like that, because some of these are unpublished cases. Okay, they exist, but they're unpublished. So what I was doing was pulling up the ones that had the Supreme Court code. So what we're going to do is we're going to stop this because I want you to be able to hear the end, but I'm going to get rid of these right here because many of you who have watched my videos know these codes because I've quoted them many, many times in my cases. As a matter of fact, let's get rid of all the top because this is just a PDF reader. Ladies and gentlemen, natural reader. And this is 11. I found 11 to be simple, easy to use, and colorful. See, it's so colorful. 1 second.
27 Question number 4. If a judge operating for an administrative agency is simply a mere ministerial clerk, do I not have the right to be before the judicial branch of the state of Washington? And if I have the right to be before the judicial branch of the state of Washington, why is it that a private agency is masquerading as an agency of the judicial branch for the state of Washington in violation of the Constitution for the great state of Washington? 28 Question number 5. The law says that any time any government agency engages in commercial business activities they willfully waive all rights to sovereignty and can be treated as any other corporation, meaning they can be sued. My claim initially before the Superior Court was that it engages in commercial business activities. These commercial business activities document the fact that they are not government. If the Superior Court is not government, the net would render each and every one of its agents from acting in an official capacity, which would make their actions unconstitutional, unlawful, and in violation of the sovereign representative capacity of agencies of the state. If this is the case, then why is the Superior Court issuing orders, mandate, sanctions when they lack the authority to do so in the first instance? 29 I have resigned as registered agent of the agency. It is impossible to prove jurisdiction exists absent a substantial nexus with the state, such as voluntary subscription to license. All jurisdictional facts supporting claim that supposed jurisdiction exists must appear on the record of the court. Pipeline v. Marathon. 102 SCT 3858 quoting Crowell v. Benson 883 The United States 22. However, this court continues to place my name in such a form so as to be construed to indicate that I am somehow under its jurisdiction, have submitted to us jurisdiction, and bound by his jurisdiction through some sort of license. What I need to know is, where is this license? Where's the proof of such jurisdiction over my person? Over my trade name? Over my estate? Please understand that these questions throughout this brief are to be considered contextually. Also note that I am not the appellee, but the appellant. 30 These questions are being asked in this appeal is being taken on the basis of the two issues presented before the court. Once again, adverse possession with the rights conferred and associated thereto, and the jurisdiction of the court would respect my right to be before the judicial branch of government, which is how I was presenting my resentments. In case it was not clear with respect the general provisions of the March 9, 1933 Act of Congress being unconstitutional, and that they themselves made it clear that they had delegated their legislative power to the executive branch of government despite the constitutional prohibitions, I have placed their intent in their own words within the body of this presentment so there can be no argument, no claim, no construing of anything being meritless, frivolous, or that the act is being misapplied. When referenced in my appeal/complaint/presentment. Forward. Since March 9, 1933, the United States has been in a state of declared national emergency. In fact, there are now in effect 4 presidentially proclaimed states of national emergency. In addition to the national emergency declared by President Roosevelt in 1933, there are also the national emergency proclaimed by President Truman on December 16, 1950, during the Korean conflict, and the states of national emergency declared by President Nixon on March 23, 1970, and August 15, 1971. These proclamations give force to 470 provisions of federal law. These hundreds of statutes delegate to the President extraordinary powers, ordinarily exercised by the Congress, which affect the lives of American citizens in a host of all-encompassing matters. This vast range of powers, taken together, confer enough authority to rule the country without reference to normal constitutional processes. Under the powers delegated by these statutes, the President seizes property, organize and control the means of production, seize commodities, assign military forces abroad, institute martial law, seize and control all transportation and communication, regulate the operation of private enterprise, restrict travel, and, in a plethora of particular ways, control the lives of all American citizens. 31 The one initial exception to the foregoing framework for national emergencies concerned the Trading with the Enemy Act. As first adopted in 1976, the National Emergencies Act excluded from its purview Section 5(b) of the Trading with the Enemy Act. As noted above, that is the provision of law under which President Roosevelt issued his declaration of national emergency with respect to the banking crisis. But with the advent of the Cold War, that section had also been used by the executive branch as the legal basis for imposing economic sanctions. As a consequence, the State Department asked that Section 5(b), the March 9, 1933 Act, otherwise known as the Emergency Economic Bank, RUPSI, Relief Act, a national declaration of bankruptcy be excluded from the National Emergencies Act until other legislation providing a basis for the continuation of economic sanctions against those countries could be enacted. There has been no further legislation provided by Congress. In fact, the United States Congress has not revisited this matter since the enactment of the National Emergencies Act of 1976. 32. I do hereby present this my appeal on this day to be construed contextually, and to have the determination made as to whether or not one has the right to do an adverse possession on a property for which they have had possession of for greater than 30 years, even if there is a claim that all properties in the United States are owned by the United States Senate Document Number 43, 73rd Congress, First Session. I have the right to property under the Right to Property Clause. I also have constitutional rights that are still in effect as I challenge the constitutionality of the March 9, 1933 Act, otherwise known as the Emergency Economic Banking Relief Act, as is my right. 33. I also challenged the statute that allows the judges of the courts of the great state of Washington to operate in an administrative capacity, camouflaging and or disguising themselves to be the judicial branch of government by carrying a name similar to that of the judicial branch. This is a blight on public perception. It blocks access to the court and to justice, and is a violation of the Separation of Powers Clause, since the courts have been delegated by the Constitution to be only of the judicial branch of government. 34. Because of the intricacies of this matter, that it involves not only constitutional challenge, a statutory challenge, a challenge to the jurisdiction of the court, a challenge to the National Emergency Banking Relief Act, and the Federal Emergency Banking Relief Act, and the actions of Congress when delegating their authority to another branch of government, the prohibition stipulated specifically within the framework of both the state constitution and the federal constitution, I must ask for a stay pending the outcome of this matter. 35. The court must issue a stay because this matter involves public interests, public opinion, as well as public perception, and it will affect the ordinary business of the court in one fashion or another, and damage will continue to be done myself as a result of the interaction of the court would respect my equitable remedy at law. There has already been harm and damage, as the Superior Court has ignored the fact that a trustee proceeded to sell my property while I have a pending adverse possession claim. The property was in bankruptcy, and the court ignored these proofs on the record, causing me great damage, stress, and harm. 36. I have a right to property, and I must insist that this court recognize that right, the right to the public to have an interest in this matter as it involves their interests, and my right to challenge the statute, the actions of Congress, and the jurisdiction of the court, which means that the court does not issue a stay, it will be ignoring that which I have a right to have acknowledged, a cognizable reason and a cognizable justification for the court issuing a stay which will not harm or jeopardize any other party if it were instituted. I must ask that the stay be issued immediately to prevent any further damage and / or harm as a result of the equitable affirmative relief requested and demanded as a right as a result of the instant matter. 37. The issue still remains is I have a right to be before he constitutional venue known as the judicial branch of government, and I need this court to state with specificity where that court may be had, its address, its telephone number, and the rules and procedures for that venue, and not the administrative judicial courts which are under the administrative branch of government, which practice commercial business, continuously stripping them of any claim to sovereignty. The aforementioned is true and accurate, and is further based on first-hand knowledge of the facts contained herein, and I attest to these facts on this day, March 5, 2018, as such, so help me God.
So help me. Okay, ladies and gentlemen, as you can see, this is an actual appeal being done on an adverse possession claim. So I played this so that you guys will see the arguments being put forth and the questions. If it's done right, if you do yours right, within that state, you're asking a legal question, several legal questions in that. That means if you do it right, especially if you're involved in foreclosure, you can bring everybody else who are involved in foreclosure under yours, so where it will literally stay all foreclosures associated with the same argument. Okay, so I will let you go, but this is so you guys can get an idea, because some of you guys don't know how to write for yourselves, so I do these videos so you can see how to do your appeal. If yours is an appeal and it's involved in foreclosure, use some of these arguments. It doesn't necessarily have to be an adverse possession appeal. It's the arguments that you're looking for. I hope that you have a good time, a good life, a good night, a good day. Goodbye.